is an evidence session on the Scottish Government's handling of harassment complaints, where we will hear from the Lord Advocate, James Wolfe QC, and the Crown Agent, David Harvey. Can I remind all those present and watching that we are bound by the terms of our remit and the relevant court orders, including the need to avoid contempt of court by identifying certain individuals, including through jigsaw identification. The committee as a whole has agreed that it is not our role to revisit events that were a focus of the trial. That could be seen to constitute a rerun of the criminal trial. Our remit is to consider and report on the actions of the First Minister, Scottish Government officials and special advisers in dealing with complaints about Alex Salmond, former First Minister, considered under the Scottish Government's handling of harassment complaints involving current or former ministers, and procedure and actions in relation to the Scottish Ministerial Code. Margaret Mitchell.
Thank you very much, Convener, and can I thank the Lord Advocate for his opening statement. Both the Lord Advocate and the Crown Agent I am very familiar with in my previous role as the Convener of the Justice Committee. We have had productive and a good working relationship in the past. However, it has to be made absolutely crystal clear that the Lord Advocate, as head of our independent prosecution service, has a duty under the Scotland Act for all decisions taken in the public interest by the Lord Advocate as the head of that prosecution and by the Crown and Procurator Fiscal Service themselves. That being the case, he and he alone can answer and has a duty under the Scotland Act to answer for any decisions taken by the Crown and Procurator Fiscal, regardless of whether he recused himself or had no part in that decision. And it is on that basis today I seek his view of why the Crown and Procurator Fiscal Service, in sending the letter to the corporate body about their decision to publish the revised submission from the former First Minister, was seeking to impose more stringent restrictions on the Parliament and its ability to publish than it was deemed necessary for the Spectator to publish. Can the Lord Advocate, as head of the Independent Prosecution Service, confirm he has that duty and he alone has that duty? And can he explain if that was justified, that letter was justified, and if it is in fact justified to have or seek to impose more stringent restrictions on the Parliament's publication policy than it is for the Spectator, where what they published was exactly the same as the Parliament published. The Spectator was deemed lawful, no challenge was given or taken against them, but it was against the Scottish Parliament and the corporate body.
Yeah, thank you. Can I first of all say that it's entirely routine for me to be accountable for decisions in which I took no part. That's what I do all the time. Most prosecutorial decisions are taken by professional prosecutors without reference to me, and it is a great strength of our system that I commission Crown Counsel who exercise to the full my prosecutorial functions without reference to me. At the same time, I am entirely and solely, personally, constitutionally responsible and accountable, including to this Parliament, for all of those decisions. So I would not want there to be any doubt in the member's mind or anyone else's mind about that. Can I perhaps explain the position in relation to dealing with contempt of court matters? I think it's necessary that the public and members have an accurate understanding of the position. Any restrictions that on what can be published flow, in this case, from the court order, which has been made by Lady Dorian. It is for anyone who is publishing material to satisfy themselves, including by taking their own legal advice, what they can and cannot publish. The Crown does not give legal advice, nor can the Crown give a ruling on whether any publication does or does not constitute a contempt. Only the court can do that. And even if the Crown does not draw potential contempt to the attention of the court, anyone else with an interest may do so. That said, the Crown considers that where a potential contempt is drawn to its attention, it has a responsibility to seek to ensure that court orders of this sort, made to protect the administration of justice and the interests of complainers, are observed by drawing that issue to the attention of the publisher. That is a routine feature of Crown work, albeit more usually in the context of pre-trial publicity. It's well understood and it's well respected, generally speaking, by the mainstream media. The Crown cannot and does not, and indeed could not, proactively police all media outlets. It can only deal with issues that come to its attention. And in relation to issues surrounding the present order, the challenge which is concerned with protecting the identity of the complainer and complainers, the issue arises because of what is called jigsaw identification, the potential for different pieces of information to be put together in a way that would result in a breach of the court order. So far as what happened last week is concerned, the anticipated publication by the Parliament of the submission was the subject of representations to the Crown by complainers and their solicitors. The Crown reminded the parliamentary authorities, I'm sure they needed no reminding of the order. It was only when the submission was published that the Crown was able to assess it in full, and it formed the view that certain parts of the submission were liable to be a breach of the court order. The Crown drew those concerns to the attention of the parliamentary authorities. The parliamentary authorities took a decision, and it was a matter for them to redact certain material. Now, I'm conscious that of the point that the member has made, that other publications have taken a different view. And it's fair to say that the Crown, in dealing with those publications, was focused on particular aspects of the submission. In the context of the submission that appeared on the Parliament website, additional matters were identified, drawn to the parliamentary authorities' attention, and the parliamentary authorities took the view that they did.
It doesn't explain why identical submissions were released from the Spectator and from the corporate body, yet it was only the corporate body that was subject to the Crown suggesting there may be a contempt and therefore more stringent restrictions. And the Lord Advocate explained why that is the case, because clearly that is not a reasonable or a satisfactory situation for the Parliament to find itself in when we are looking to establish the facts and look independently as a committee at what took place and to establish and receive the documents we need, which will not breach contempt of court, to carry out our remit.
Reasons I gave a moment ago, it's for the Spectator to take its own legal advice and to consider whether it should take the same course as the parliamentary corporate body. The Crown at no time gives any clearance or assurance that any particular publication is or is not a contempt for the reason that I explained a moment ago. Can I also make clear that the restriction that the court order places is on publication? It does not prevent the Parliament taking into account material that has been provided to it. So the issue is only concerned with what can be put up on the Parliament website, published to the world. As I said a moment ago, it's for publishers to form their own view as to what is or is not a contempt. The Parliamentary Corporate Body has taken the view that it has. In my view, it was right to do so, the decision follows from their view and it accords with the Crown's view of the court order.
I merely say, Convener, I think people will wonder why the Crown sought to intervene in the Parliament's publication, but not in the Spectator's when it was aware they were identical publications. There will be for others much greater legal minds than mine or the committees ponder over what has been said.
Yes.
But I welcome the fact, Convener, you have allowed this discussion, and the Lord Advocate has answered in his capacity as the head of Scotland's independent prosecution.
Thank you, Ms Mitchell. I'd like the Lord Advocate give a short comment on what you just said, as I see that he tried to intervene, and then we'll move on to Alistair Allen, to be followed by Murdo Fraser. Lord Advocate.
Yeah. Yes. Can I just be clear that the Crown has not cleared or given any assurance in relation to any other publication? It is correct that additional features of the submission were identified that had not previously been identified by the Crown in the context of the submission that was put up on the parliamentary website. It's a matter for other publishers to take their own legal advice and to consider what they should be doing in order to comply with the order of the court. And all of us, I would like to think, including all members of the committee, would be concerned to ensure that nothing be done, regardless of whether there were an order of the court, to identify the complainers in the criminal trial. But as it happens, there is an order of the court and it must be complied with.
I'd like to hear a little about the Spectator case here. Again, I don't know if this is one that the Crown Agent wants to offer a view on as well, but we've obviously all heard about Lady Dorian's judgment in the incidental application by the Spectator, which sought to vary the court order laid down in the case of Her Majesty's Advocate versus Alex Salmond. Can you give some indication of what your understanding exactly is about what that judgment means in terms of how Lady Dorian's decision compares to the pleas in law that were made by the applicants themselves?
Yes, and I should say that Lady Dorian's judgment is publicly available on the Scottish Court's website, so this, that it can be read by anyone who wishes to read it. As I've read that judgment, the Spectator invited the court to vary its order in two ways. One, by making a particular adjustment to the wording, and then specifically excluding from the effect of the order evidence in the submissions to the committee and various other material. Lady Dorian declined to accept the submissions of the Spectator in that regard. She made very clear that the question of publication of the committee's proceedings were not a matter for her to rule on, that her only concern was whether the order that she had made was sufficiently clear and precise in terms of what it stated. She made a very minor adjustment to the order, not an adjustment suggested by or sought by the Spectator. And she was clear that that minor adjustment did not alter the practical effect or legal scope of the order.
Thank you, Convener.
Andy Whiteman, to be followed by Jackie Bailey.
Thank you very much, Convener, and welcome, Lord Advocate and the Crown Agent. I should just declare for the record that I'm a member of the corporate body and therefore aware of the correspondence that has taken place between Crown Office and the corporate body. Lord Advocate, I wonder if you could just clarify something you said in your opening remarks, that it is the job of the Crown Office to advise publishers in relationship to contempt of court. But you then went on to say that you don't provide legal advice. I understand there obviously is a distinction, but can you just clarify that your role in advising publishers goes no further than drawing to their attention concerns that you have as to the possibility that a contempt might be being committed?
Yes, I'm really grateful to you, Mr. Whiteman. I mean, that's exactly right. I thought I had said that it's not the Crown Office's role to advise publishers. But the Crown Office, as I explained, in order to protect the integrity of the administration of justice, will draw to the attention of publishers any concerns that the Crown has about the terms of any publication. It is for the publisher then to take its own legal advice, and ultimately only a court can decide whether a contempt has been committed. A publisher could, on its own legal advice, take the view that the Crown is wrong and take the run the risk, take the potential that that it may have to be argued in court. Equally, the Crown simply cannot and does not purport to police the media. It relies in this regard on matters being drawn to its attention. If things are drawn to its attention which give rise to a concern about contempt, then it will very properly raise them with the publisher, and the publisher will then have to consider what the right thing to do is.
And in respect to that, can I ask you whether you have indeed raised any further concerns to the Spectator magazine, further to the correspondence you had with them on the 15th of January this year?
I'm afraid I'm not aware of the current position in relation to the Spectator. I can perhaps follow that up with the committee if that would be helpful.
That would be very helpful. Furthermore, on the question of contempt, do you accept that there's been limited litigation in this field, that it is difficult to understand where the lines are drawn in relationship to contempt? For example, on a spectrum where no one says anything at all about anything that has any bearing whatsoever on the matter, and you've got complete opaqueness. The other end of the spectrum, where you publish the names of the complainers on the front page of a newspaper, there is a substantial grey area that may be a differing length, and it's hard to know often for publishers to know where the line is that they may be crossing. So, for example, would information lead to one person identifying a complainer through Jigsaw? Would it have to be 100, 1,000, etc.? Do you accept as a general principle that the law in this area is unclear and might benefit from guidance, perhaps from the Crown Office or others in future, particularly where it engages a Parliament, which has very specific responsibilities, in order to better understand the parameters of what might constitute contempt in any particular case? Yes.
I think the touchstone here has to be the terms of the order in this case. Contempt issues usually arise in the context of pre-trial publicity, where there are particular rules and where the Crown from time to time raises issues with publishers. You're absolutely right, Mr. Whiteman. There's been little litigation in this area, principally because the media understands those rules and is, generally extremely respectful of the need to comply with them. In a case like this, I suppose the starting point is the terms of the court order, which is an order preventing the publication of the names and identity and any information likely to disclose the identity of the complainers in the particular criminal case, with now the addition of the words as such complainers in those proceedings. I appreciate the point that the member is making, that at one end of the spectrum is would be a publication that named individuals and said that they had been complainants in the criminal proceedings, an absolutely clear breach of the order, and the difficult areas arise where information is published which, put together with other information that's in the public domain, could identify those complainers. Now, that's a well-recognised. The order can be breached by doing that. I think one needs to be very clear that the publication of information which, put together with other information in the public domain, would identify the complainers, is a breach of the order. And I appreciate that it is difficult for publishers, as it is for the Crown, because the Crown can, the Crown is not monitoring the media. The Crown, has to proceed on the basis of matters that are drawn to its attention. But I'm afraid, it's the responsibility of publishers in this area to, to consider carefully what they're publishing. They know the terms of the order. It's for them to, on the basis of their own legal advice, take a view. The Crown, as you correctly pointed out, will draw any concerns it has to the attention of publishers. The Crown cannot give a clearance or assurance precisely because it's not itself monitoring the media as a whole. Whether the law itself needs clarification, or whether it's some of the practical challenges of complying with the law, is perhaps a question. What one would hope is that all publishers, in good faith, would be seeking to avoid, at any cost, putting themselves in a position where they disclose the identity of complainers in a criminal trial. Both because it would be a breach of the order, but also because it would be the wrong thing to do.
Thanks very much. Can you just confirm as a matter of law that, for example, a publisher in Germany is not bound by the court order?
I don't think it'd be wise for me to comment on German law.
Okay, thanks.
Can I now move on to Jackie Bailey, please?
Thank you very much, Convener, and good morning to Lord Advocate and the Crown Agent. Just a couple of things I want to explore before I move on to my questioning. And let me start with the Spectator article, because I think the Lord Advocate, in referencing this, said that there would be no clearance or assurance given by the Crown. But I'm wondering whether that is strictly accurate, because in a pre-meeting before Lady Dorian's hearing, between Levian McRae and Alex Prentice QC, my understanding is Mr. Prentice said that there were no other concerns with the Spectator article. Is that correct?
Well, my understanding is that at the in any discussion of the Spectator article, there was particular focus on a particular paragraph of the article. I can't speak to precisely what was or was not said in that meeting, but what I can say is that the Crown cannot give a clearance or assurance, because it's not in the Crown's gift to determine whether or not a particular article is or is not a contempt. And that's well understood by publishers, that they have to take responsibility for their own publications. Now, at that, as I understand it, at that meeting, there was the particular focus was on a particular paragraph. When the matter was revisited, I suppose, in the context of the material that was published on the Parliament's website, additional areas of concern were identified by the Crown. Those were drawn to the attention of the parliamentary authorities, and the parliamentary authorities took the view that they've taken.
Ms. Bailey?
Oh, thank you. The Lord Advocate, just like myself, we weren't in the room, so we can only guess at what went on, although we've been written to by Levy and McRae, and I think this exists in our papers. And there is a suggestion that Alex Prentice QC said there were no other concerns with the article. Now, it is true that you haven't written as the Crown Office to the Spectator since the 15th of January. Is that correct?
Well, I don't know if the Crown Agent can help me with that. The Spectator will no doubt have been watching events. It's for the Spectator to form its own view about about what it may lawfully publish and what it may not lawfully publish.
I absolutely understand that, but what I'm suggesting is, given that the Crown Office hasn't written since the 15th of January, don't think clearly by your actions there's any urgent need to get the Spectator to redact more. And the reason I'm pressing that point is, the paragraphs that you sought to get redacted from the Scottish Parliament's evidence on its website are remarkably similar, if not identical, to the ones that people can see today on the Spectator website.
Lord Advocate?
As I've said before, the Spectator, I have no doubt, and its legal advisors will have been watching, observing what's been happening. They are well aware of the position one may take it. It's for them to consider what they may lawfully publish and what they may not.
Okay.
I have Stuart McMillan followed by Maureen Watt.
Just regarding the corporate body decision, and some of this has been discussed earlier on, but I'm really just trying to seek some clarity on the process that would have happened. Earlier on in your comments, Lord Advocate, and I'm paraphrasing you here, that you touched upon, you gave a short explanation as to the process that would have happened. Complainers would have went to the Crown would have went to the Parliament, and the Parliament acted the way it did by redacting information. So as a consequence of that, would the Crown Office be telling the Parliament's corporate body what it could or could not publish?
To tell a publisher what they can and can't publish, the publisher has to take responsibility for itself. The publisher knows the terms of the court order. They should have access to their own legal advice. The Crown will express concerns. It may express its own view about the interpretation of the court order, but it is always for the publisher itself to take its own view, not least because the only person who can determine whether a publication is a contempt of court is the court itself. And that matter may be raised before the court not only by the Crown but by other parties who have an interest.
Okay, thank you. So with that, the advice that the Crown Office will have given to the corporate body following its publication, would that advice have differed from the advice the Crown Office will have actually given to the Spectator magazine or any other publisher following publication?
As I explained in previous discussions, when the issue of the Spectator publication was being looked at, there was a particular focus on a particular paragraph, and that was addressed. It was frankly only when the matter came back in the light of the publication by the corporate body that certain other matters were identified that gave rise to concern. Now, the issue here is how one puts a particular piece of information, how what one takes from it in light of other information. So it's not, that's the position. That's the position. And as I say, once those issues were identified by the Crown, they raised them with the corporate body. The corporate body clearly agreed or accepted that view.
In the case regarding the corporate body, has the Crown been in receipt of any complaints about the Spectator or any other publisher about what they have published?
I'm afraid I'm not in a position to answer that at this moment.
Okay, Thank you. In terms of once again, just regarding the corporate body, could it have been the case that if the corporate body had simply decided to redact further than what the Crown Office had actually highlighted, so that decision, just for clarification, that decision would have been taken by the corporate body as compared to by the Crown, is that correct?
Ultimately, any decision, whether it reflects the concerns the Crown has raised or is different, is a decision taken by the publisher themselves.
Okay. Okay, thank you. And just one final question from me, convener. Certainly, Mr. Salmond's submission was available from Spectator online for an extended period of time. And certainly not one Scottish publication decided to publish that particular submission until after it was published by the Scottish Parliament's corporate body. Would that have been because, or potentially have been because, of the advice, the legal advice that the newspapers will have been receiving from their own lawyers, indicating that there was a kind of legal prohibition by the court order regarding that particular submission?
I lost the start of that question.
Okay, sorry. So Mr. Salmond's submission was available from it was on the Spectator website. It was on there for an extended period of time, and not one Scottish newspaper decided to actually publish that submission until after the Scottish Parliament's corporate body had actually published it. Now, would that have been because of the legal advice that the newspapers will have been receiving, obviously from their own private legal advice, bearing in mind the legal prohibition that would have been put on it by the court order?
Well, I mean, I can only presume that any publisher will, take their own legal advice and make their own decision in light of that advice.
Okay.
But obviously, one would have to direct the question to them as to what actually happened.
Sure. Thank you very much, Lord Advocate. Thank you, convener.